The judges of our court typically, and the reason is, Mr. Reamer could appreciate it, is it would take me too far away from my beloved Crimson Tide. The judges of our court typically decide appeals with panels of 3 judges, which means you learn quickly to count to 2 to obtain a majority. But the vast majority of our appeals, more than 95%, are decided unanimously. In a rare appeal, all 12 judges of our court will, by a majority vote, decide whether to rehear a difficult appeal with the full court sitting. We decide about 85% of our appeals without hearing oral arguments. That is, we read the written briefs from the lawyers and the record from the district court to decide the appeal. In the other 15% of the appeals, which are the more difficult cases, we sit together as a panel of 3 judges and hear oral arguments in 15 to 20 appeals in 4 consecutive days. We hear death penalty appeals separately. There are 12 active judges on our court, 3 in Atlanta, 3 in Alabama, 4 in Georgia, and 5 in Florida. The other Alabamians, Chief Judge Joel Dabena and Judge Ed Carnes, live and work in Montgomery. 3 of our Georgia judges, Judge Larry Edmondson, Judge Frank Hull, Frank is a woman, and Judge Beverly Martin live and work in Atlanta. We have 1 vacant judgeship today in Georgia, and the president has not yet nominated someone to fill that vacancy. 2 of our Florida judges, Judges Rosemary Barquette and Stanley Marcus, live in Miami. 2 other judges, Judges Jerry Choflat and Susan Black, live and work in Jacksonville, and the remaining Floridian, Judge Charles Wilson, lives and works in Tampa. We also have several judges who have retired to what is called senior status in the 3 states, and those senior judges help us enormously on a part-time basis with our work. One of those senior judges, Emmett Rip Cox, lives and works in Mobile, my hometown. I was appointed to fill the vacancy on our court when Judge Cox retired to senior status. The judges of our court have varied legal backgrounds. 4 other judges on our court were, like me, prosecutors during parts of their career. 3 judges, Marcus, Wilson, and Martin, were United States attorneys, and the other, Judge Ed Carnes, worked as an assistant attorney general of Alabama. 6 of our judges, Choflat, Dabena, Black, Marcus, Hull, and Martin, previously served as trial judges on federal district courts. 3 of our judges, Choflat, Black, and Barquette, served earlier as state trial judges in Florida. 2 of our judges, Dabena and Wilson, served as federal magistrate judges. 1 of our judges, Rosemary Barquette, previously served as the Chief Justice of Florida. 1 of our judges, Larry Edmondson, engaged primarily in the private practice of law before his appointment to our court, although others of us also engaged in private practice for some years. So I guess the moral of this story is if you want to get on our court, go to work for the government. 5 of our judges began their careers as law clerks to other federal judges. 2 of our judges, Edmondson and Dabena, served as law clerks to federal district judges, and 3 of us, Frank Hull, Charles Wilson, and me, served as law clerks to judges on the old Fifth Circuit. Judge Hull served as a law clerk for Judge Elbert Tuttle, for whom our Atlanta courthouse is named. The courthouse for the Fifth Circuit is named after Judge Wisdom, for whom I served as a law clerk. Now, Judge Wilson served as a law clerk for the judge he later succeeded, Joseph Hatchett, and they are the only African Americans who have served on our court. All of our judges were appointed by the President of the United States for a term of life. Our appointments were confirmed by a majority vote of the Senate. Congress decides by law the number of judges on each of the courts of appeals. Our judges also have varied political backgrounds. 1 judge was appointed to our former court, the Fifth Circuit, by President Ford, and that judge had been appointed to the district court by President Nixon. 1 member was appointed to our court by President Reagan. 3 were appointed to our court by the first President Bush. 1 of those judges had been appointed to the district court by Reagan, and another had been appointed to the district court by President Carter. 4 judges were appointed to our court by President Clinton. 1 of those had been appointed to the district court by President Reagan, and another had been appointed to the district court again by President Clinton. 4 judges, including me, were elected to public office before serving on our court. I'm the only member of our court who was appointed by the second President Bush, and one of our judges was appointed by President Obama. Our judges also have varied educational backgrounds. 3 graduated from Harvard Law School, 1 graduated from Emory, 2 from the University of Florida, 2 from Georgia, 1 from Cumberland, 1 from Duke, 1 from Notre Dame, and I'm the lone one from Tulane. One of our judges, Stanley Marcus, regularly teaches 2 different courses at law schools. I teach federal jurisdiction each fall, as was mentioned, at Alabama. I have taught there for 5 years. Many of our judges regularly deliver lectures at law schools and bar association conferences. I've lectured in recent years at Columbia, Virginia, Tulane, and Florida, and later this month I'm going to serve as a jurist in residence at Florida State. The other judges on our court are terrific and brilliant colleagues. As a citizen, you can rest assured that we work hard on every appeal that comes before us and strive to treat every litigant with respect. We have a highly collegial court. That is, we enjoy working together and respect each other. And unfortunately, fairly well known within the legal profession, that has not always been the case in recent years on some of the other circuit courts that have had a lot more in the way of kind of famous or infamous personality conflicts. We are a highly collegial court. When we work together in the same city, we like to dine and enjoy social occasions with each other. The oddest moment for me came in my first year on the court because President Bush's appointment was during a recess of the Senate while my confirmation was being debated. My appointment was temporary, a party to one of the rare appeals being heard by our entire court, that is all 12 judges, objected to the validity of my recess appointment, and the late Senator Edward Kennedy of Massachusetts filed a friend of the court brief in support of that objection, written by none other than a Harvard law professor. I recused myself, as did my colleague Ed Carnes, who had administered my first oath of office, and the full court ruled that my appointment was valid and constitutional. It was strange for me to await that decision, but I knew that my colleagues would give it an honest assessment based on each judge's studied view of the law. When we later decided the merits of that appeal, by the way, I voted in favor of the party who had challenged my appointment. I have recused myself from all appeals involving the state of Alabama if the matter arose while I served as Attorney General. I am, for example, recused from death penalty appeals and other appeals involving Alabama prisoners, particularly those who've been serving since before 2004. I'm also recused from many civil appeals where a state agency or official is involved. Many of our court employees work in our main courthouse in Atlanta, in the clerk's office, and in the circuit executive's office. We also have an office of staff attorneys there where about 55 to 60 court attorneys assist us in our work, especially the routine appeals that we decide without hearing oral arguments. All of these employees are career public servants who are exceptional professionals. In our individual chambers, each judge has 6 employees. We have a judicial administrator, 4 law clerks, and a staff attorney. Because our chambers are small, we value employees who are team players and who respect the confidentiality of our deliberations. My favorite aspect of the job is training new law clerks each year, young lawyers from across the country, including many who are about to graduate from law school, apply to work for us as law clerks. They work ordinarily for a term of 1 year. We receive applications from the best and brightest, including graduates of Ivy League schools, editors of student-run law reviews, and clerks on federal district courts. The application process is highly competitive. Last year, I had clerks from Duke, Michigan, Alabama, and Regent. My current clerks graduated from Harvard, Stanford, Alabama, and Pepperdine. Next year, my clerks will be from the University of Chicago, from UVA, and Tulane. The Yalie is a native of Dothan who graduated from Birmingham Southern. The Virginia student is from Birmingham, graduated from Auburn, and served as a managing editor of the Virginia Law Review. The Tulane student is clerking for a district judge in New Orleans, and last year served as editor-in-chief of that distinguished law review. One of my former clerks is serving this year as a clerk for Justice Clarence Thomas on the Supreme Court, and one of my former clerks next year will clerk for Justice Samuel Alito. My staff attorney graduated from Cumberland and worked for a decade in the Office of Attorney General, where I hired her following her graduation from law school. I like clerks with roots in Alabama, but my overriding objective is to hire law clerks who have the intelligence, personality, and drive to do the best possible work for the United States. My own interest in serving as a circuit judge dates back to when I served as a law clerk for Judge Wisdom in 1987 and 1988, but I doubt I would have made the cut to clerk for me. That sums up what I wanted to say about our court. Again, it is a job I love, and I hope I am able to live long enough to do it for many more years. I can think of no greater responsibility than to be sworn to administer equal justice under the Constitution of the United States. I would be pleased to take a few questions. Thank you.
Do you might have any questions for Judge Pryor, Robert?
Is there a short story or explanation behind the system that we currently have today? And are there any arguments against the system that we have? And in your opinion, do those arguments have any merit?
What do you mean, the system that we have? Like the system of representative democracy?
Yeah, I guess we've got all these different appeals courts. How did all those come to be, the structure that they have?
Okay. The short of that, for those who took my course in federal jurisdiction, like Kevin Garrison, who knows something about the federal courts, Adam didn't take my course, so he doesn't know anything about it. But the short story is that for the first 100 years or so, the first century, we had trial courts and the Supreme Court of the United States. And in fact, Supreme Court justices rode circuit. That is, they would go and sit on trial courts. And there was a big debate about that, whether that was wise. The justices of the Supreme Court hated it. In fact, when the Federalists were going out of power, right before Marbury versus Madison was decided, and the Jeffersonians, the wild Jeffersonians, were coming into power, the populists, the Federalists created an appellate court system much like the one that we have in the Judiciary Act of 1801. One of the first things the Jeffersonians did when they came in was repeal the Judiciary Act of 1801 and abolish those courts, so they never really got up and running. But finally, it was decided that we needed to stop the practice of having justices of the Supreme Court ride circuit. In the Reconstruction era, the thought was we wanted the federal courts to be more involved in enforcing the civil rights that Congress was created. That was going to create a lot more work for the federal courts. So the idea was to create an intermediate system of appellate courts and have a justice assigned to each of those courts as a circuit justice. And that's basically